Good morning. I'm Lisa Palazzo from the University Compliance Office. Thank you for your interest in privacy in higher education. Because this session is being recorded, please hold your questions until the end. Following the presentation, there will be time for questions and answers. That portion will not be recorded. There is certain information about me that I want to keep private. I would be unhappy if it were generally broadcasted, such as my salary, my age, weight, health conditions, the books I choose to check out from the library, classes I may enroll in while working here, the grades I earn in those classes, the content of my employment review. It almost goes without saying that we have legitimate expectations of privacy in those delicate pieces of information. I'm not alone. This expectation of privacy is very much a part of American culture. Privacy translates to an expectation that we're in charge of our own personal lives and we're therefore the proper custodians of our personal information, that we should have a say in who does and does not have access to that information about ourselves. As an active university, we often need personal information to engage in our goals of teaching, research, and service. In fact, all of those facts about me could be found somewhere in the legitimate business records of the university. We need to be aware of how this information can be misused so that we can avoid the harms associated with that. If sensitive information of our students, faculty, and staff were misused, it could be used to embarrass or victimize members of our community. The same could happen to other individuals for whom we hold sensitive information. Think alumni, donors, research collaborators from other institutions, even relatives of employees and students. In this playing field, our university's goals are to develop and maintain a comprehensive privacy program by identifying our risks, creating and updating appropriate policies, providing guidance, training employees, keeping informed of new legal and technological developments. The Compliance Office has been taking steps in all of these areas. Not only do universities typically have custody of a lot of personal information, but due to the computer age, where and how we store this information is changing rapidly. It used to be that all of our individuals' information was stored on paper in files in hopefully locked drawers. But now, as documents are stored and transmitted electronically, securing that information is more complex and it's more vulnerable to hacking, loss, and theft. Also, we're required to comply with many federal and state privacy laws regarding how we can collect, store, and use the personal information we have. With an understanding of the requirements, we can work through what we need to do to be proper stewards of the information in our custody. One challenging aspect of the U.S. regulations regarding privacy is that they're fragmented. There's not one single comprehensive set of laws that covers all personal information. Instead, they're broken up by subject matter and business area. For example, some regulations cover student records, some cover health records, some financial records. It can be challenging to see how they fit together. This slide lists some of the legal standards we're held to. FERPA stands for the Family Educational Rights and Privacy Act, and it tells about how universities and other educational entities should use and disclose students' education records. Because it's one of the most important sets of regulations for universities, we'll discuss it generally in a moment. We give a more detailed discussion of FERPA in the FERPA-specific Speaking of Privacy session. HIPAA stands for the Health Insurance Portability and Accountability Act, and it tells about how organizations that hold individuals' protected health information, PHI, can use and disclose it. Under HIPAA, CASE is a hybrid entity. This means that some components are subject to HIPAA while others are not. We'll discuss HIPAA generally in a moment, but individuals who work at CASE within a covered entity could learn more from the targeted HIPAA session. We'll also briefly review the Graham-Leach-Lively Act, which discusses financial information. We'll touch on state privacy laws, standards surrounding payment card transactions, and also international data protection requirements. Now, FERPA. Congress passed FERPA in 1974, and since then there have been many misunderstandings and misconceptions about what FERPA means and how schools should operate to be consistent with it. Primarily, it's helpful to think of FERPA not as about student privacy per se, but about privacy of the student's education records. For elementary school students, FERPA gives their parents the right to have access to their children's education records, the right to seek to have those records amended, and the right to consent to the disclosure to third parties of personally identifiable information from education records, with certain specified exceptions. What's important for us to know is that when a student turns 18 years old or enters a post-secondary institution at any age, the rights under FERPA transfer from the parents to the student, and he or she is considered an eligible student under FERPA. So here at CASE, all of our students are eligible students. They all have FERPA rights to exercise. Public and private schools that receive federal Department of Education funding have to comply with FERPA. So therefore, FERPA does apply to our university. It's important to understand how FERPA defines education records. Education records are those records that are directly related to a student and are maintained by the educational agency or institution or by a party acting on their behalf. So this is quite a broad definition. There are some exceptions to that definition, though. I won't get into all of them today, but I'll point out a few of the most important exceptions. First, education records that have been scrubbed of identifiers, so completely anonymized records, are not covered by FERPA. Law enforcement unit records. Specifically, these are records created and maintained by the school's law enforcement unit, like campus security, for the purpose of law enforcement. Also, alumni records are not FERPA records. Specifically, this is information about a student once they've graduated, once they're no longer a student. Also, a big exception is personal observations. Those myths and misunderstandings I mentioned before come into play here. It's a myth that FERPA applies to all student information. It does not. It only governs records and information from records, not information that's generally known about a student. To illustrate this distinction, let's say an RA notices a student becoming withdrawn and uncommunicative, really a drastic change in their behavior. That personal observation is not a record and is therefore not covered by FERPA. FERPA gives eligible students the right to access their education records and the right to seek to amend them. One of the whys behind FERPA is to allow eligible students to challenge the content of their education records to make sure they're accurate, to make sure they're not misleading, and to give them the opportunity to correct them if they believe they are inaccurate. Also, FERPA gives the eligible student the right to consent to disclosure of information from their education records to third parties of personally identifiable information from their education records. This, I think, really is the crux of what a lot of people think of when they hear the word FERPA, the rules regarding how and when institutions may or may not release information from education records to outside parties. And what FERPA generally holds is that institutions cannot release personally identifiable information, or PII, to outsiders without the consent of the student. That's the general rule. So what is PII? PII is information containing direct or indirect identifiers. Direct identifiers are items such as name and address of a student. Indirect identifiers are information that simply would have the effect of identifying the student in the end. The standard is whether a reasonable person in the school community, someone with personal knowledge, could use that information to actually identify the student. There's a type of PII, personally identifiable information, that is not generally considered an invasion of privacy if it's disclosed to outsiders, and that's called directory information. Directory information includes items that you might find in a student directory, a yearbook, a playbill, a sports program, generally items that would normally be open to the public. However, directory information cannot include a student's social security number and generally cannot include a student's ID number. Schools are permitted to adopt a limited directory information policy that allows for disclosure of directory information to specific outside parties and for specific purposes. However, schools are required to first give notice of this directory information policy to its students and give the students the right to opt out. To reiterate, an important right that eligible students have under FERPA is the right to provide consent before PII from education records is disclosed. For disclosure of non-directory information, like grades, for example, the institution would first need the student's written consent. FERPA dictates that written consents must be signed and dated by the student and must specify the records that may be disclosed. The consent must state the purpose of the disclosure and identify the party or class of parties to whom the disclosure may be made. For disclosure of directory information, you don't need this specific written consent each and every time, but you do need to make sure that the student didn't opt out of the directory information program. To summarize, FERPA requires an institution to disclose to an eligible student the student's education records, and FERPA permits an institution to disclose education records to outsiders in certain situations. There are quite a few exceptions to FERPA's requirement to get this consent, and we'll discuss them in detail during the FERPA-specific session. If an eligible student believes that her FERPA rights have been violated, she may file a written complaint with the Family Policy Compliance Office regarding an alleged violation, but she must submit the complaint within 180 days of the alleged violation. Schools are required to annually notify students of their FERPA rights, and we do this on the web pages of our university registrar. The pages include an explanation of the FERPA rights, the process for requesting review of education records, and the process for amending education records. The case notice regarding directory information can also be found on these pages. The web pages specifically bullet directory information items for users' easy reference. And they're shown on this slide. The registrar's website includes information for students who would prefer that the university not release their directory information, such as instructions on how to update their FERPA restriction by going to the Student Information System, or SIS. How can CASE employees check whether a student has opted out of the directory policy? If a student requests that their directory information not be released without their written permission, a symbol will appear in the Student Center on the student's record in SIS. However, it's best to check with the registrar's office on decisions regarding student records release in all cases. Finally, the registrar's web pages include helpful resources regarding FERPA, including a 10-minute training video explaining how employees should handle specific record request situations. We encourage you to visit these pages frequently to keep your awareness of FERPA up to date. Now we turn away from education records and consider another type of record attached to privacy-related duties, health records. HIPAA is a complex framework of privacy regulations addressing the privacy of individuals' protected health information. Congress enacted HIPAA in 1996, one goal being to improve the efficiency and effectiveness of the healthcare system by creating national standards and requirements for electronic healthcare transactions, and to protect the privacy and security of individually identifiable health information. The Department of Health and Human Services, HHS, has issued a host of rules, including the privacy rule, to implement these provisions. Entities subject to HIPAA are known as covered entities. They include health plans, healthcare clearinghouses, and healthcare providers that transmit health information in electronic form in connection with certain covered transactions. As I mentioned, CASE as an institution is not a covered entity, but it contains components that do meet the definition of covered entity. Thus, the university is considered a hybrid entity. As such, only its designated healthcare components are subject to and must comply with HIPAA and its privacy and security rules. The privacy rule of HIPAA requires covered entities to have in place appropriate administrative, technical, and physical safeguards to protect the privacy of protected health information. The security rule describes the framework for organizations, such as our designated healthcare components, to exercise the privacy requirement and secure PHI. Those administrative, physical, and technical safeguards established by HIPAA provide a good framework for all of us generally to consider how we handle sensitive information in general. When developing practices in our own offices regarding how we manage sensitive information, we can ask ourselves about the physical protections we're using. Are we putting papers containing sensitive physical information in locked drawers overnight? We think about administrative safeguards we may or may not be using. If our office typically handles sensitive information, do we have employees sign confidentiality agreements? We also consider technical safeguards. When it comes to sensitive information that employees can access on our electronic systems, do we have role-based levels of permission, access to that sensitive information based on individual roles? This has been a very quick look at HIPAA. If you're interested in learning more, I recommend our HIPAA-focused session. The Gramm-Leach-Bliley Act regulates privacy in the financial industry, but U.S. universities also may be subject to it to the extent that an educational institution engages in lending funds, like to students or faculty, collecting loan payments, or facilitating the process of or applying for financial aid. The Gramm-Leach-Bliley Act includes rules for how to use and when you can and cannot disclose non-public information. This review of federal privacy-related regulations, I think, drives home the point that there's a lack of a comprehensive federal framework of national privacy laws, and it can be challenging. Many states have taken up the role of privacy protection of its own citizens. This means that universities like CASE may need to comply with another layer of privacy-related laws. And a challenging aspect of this is that state laws can vary from state to state. Another challenge is that many states have started to apply, for example, data protection laws broadly to organizations that have only a relatively small reach into that state. That is, physical presence in the state may not be required for an institution to be subject to that state's privacy laws. The two most common standards for being covered under a particular state's data privacy laws are, one, whether you're doing business in that particular state, or two, whether you're holding a resident from that state's personal information. For universities, thinking about the effect, this could result in being subject to state privacy laws based not on our geographic location alone, but also the home states of the student body or even possibly the applicant pool. Some state privacy laws put extra protections on types of information that the state considers to be particularly private or particularly damaging if it were generally known. For example, Ohio has a statute making it a crime to disclose a patient's HIV status to unauthorized persons. This matters to us because individuals' HIV status could arguably be on any number of records in a university, such as in the health service, the dental clinic, counseling records, clinical study research information. Also, as with most research universities, CASE has a rich international presence in our educational and research endeavors. We teach students abroad. We conduct research abroad. We welcome international students and faculty on our campus. We collaborate with foreign universities and businesses. These activities implicate international privacy laws from jurisdictions that have data privacy laws which can be very different from those in the US. Also, federal export control laws impact many aspects of our international educational and research efforts. If we ever have export-controlled technical data in our custody, there may be limits and licensing requirements before we can disclose that data to certain recipients. Unlike FERPA, HIPAA, and the state and international laws we've discussed, the payment card industry data security standard is not a law, but applies to institutions that process credit card payments. For example, at a campus bookstore, restaurants, or dining halls. In December of 2014, Visa and MasterCard announced an agreement to coordinate their data security programs for merchants and third-party processors. This led to the creation of a standard known as the PCI DSS, which was designed to guard against attacks that involve theft and misuse of cardholder information. Depending on how many payment transactions occur at an institution annually, the payment card associations may require the school to validate its compliance with PCI DSS. For our university, any breach of our private information has the potential to result in great losses. Security incidents could arise in many different contexts. They may result in disclosure of personal information, diminished intellectual property, a tarnished reputation in the community, loss of trust among our people, reduction of economic resources and funding opportunities, and legal sanctions. Because of these potential harms, we place a very high priority on the security of our information. All individuals at CASE and all divisions, offices, departments, and schools are responsible for reporting information breaches and upholding our privacy policies and practices. The university has been doing several things to promote privacy. We've designated a privacy office. This is the compliance office, the university compliance office. We're examining our policies and practices to identify potential risks and areas for improvement. We're meeting with representatives from offices throughout the campus who collect, store, and use sensitive information to build relationships and help give information and also learn about possible risk areas. We're training employees to raise awareness. If you learn of or suspect a privacy breach, feel free to contact me or Boyd Coomer immediately, hopefully within 24 hours. The reason for this is some privacy laws have deadlines as to when we have to take certain response actions. So the clock may start ticking right when you learn about a problem. An institution may have the best practices in place, the best habits, but still, unfortunately, may have a privacy breach. For example, a building could get broken into and computers containing sensitive information could get stolen. For this reason, it's important to have consistent methods to contain a breach and respond to a breach. If and when a breach happens, or you think there may be a breach and it's reported to the compliance office, we'll start an investigation. The best case scenario, and we've had this happen, is that it was a mistake and there wasn't actually a breach. At that point, the compliance office would document it and the process would end. If there in fact was a breach, the privacy office or compliance office, I use the terms interchangeably because it's the same office, the privacy office would work with the affected office where the incident happened to contain the information leak and to assess the extent and impact of the event. The privacy office may also bring in other offices if needed. For example, IT security if the breach involved electronic information. After containing the breach, the privacy office would confer with the Office of General Counsel to determine if any specific legal protections applied and identify any legal reporting obligations. The privacy office and Office of General Counsel would work together to identify all laws that may impact the university's response, plus any contractual obligations there may be. An important part of this discussion is for the privacy office to analyze the risk of harm to individuals affected by the breach. Based on those laws impacted and any contractual notification obligations there may be, the privacy office then may send a notification letter to individuals affected by the breach. Also, the privacy office would identify whether there were any other institutional harms that would need to be addressed and would work with the affected groups to change processes. Part of this process includes the privacy office drafting a breach report, which would include the relevant facts of the breach and our institutional response, and the privacy office would maintain a copy of the breach report as a tool to fulfill reporting obligations. Everyone in the case community has a duty to appropriately uphold privacy. Certain offices have specific roles, and you heard me mention them. I'll briefly go over them again now. The privacy office, compliance office, is responsible for developing and maintaining a system-wide incident response process for data breaches. It acts as the central and first point of contact for breaches. IT security is responsible for conducting any computer diagnostic support in technology-based breaches. As touched on, the Office of General Counsel is responsible for providing legal advice during an investigation, including guidance on making any disclosures that may be required by law. Also, marketing and communications is responsible for communication strategy with the media after consultations with the privacy office and any involved campus entities. Here are some takeaways to help you properly take care of all types of sensitive information you may come into contact with while you're working a case. Lock rooms and cabinets where paper records are stored. Don't leave sensitive documents out in the open where they can be observed, like in a fax machine or photocopier. Shred documents that contain sensitive information instead of discarding them in the trash or even the recycling. The problem may be people accessing those receptacles, but even more if these things are dumped in a big waste bin outdoors, the wind could have them blowing sensitive information all over, and we don't want that to happen. Keep voices low when discussing sensitive issues when others are present. If you have calls making requests for student information, you can contact either the compliance office or the university registrar to help you with that. Some offices on campus use Social Security numbers. It's an integral process of their business operations. Have caution and sensitivity when using Social Security numbers. Generally, we do not email Social Security numbers. If someone is giving you their Social Security number and they're present it's a best practice to have them write it down on a piece of paper, and you get it, and then the paper is destroyed, shredded afterward. Speaking of Social Security numbers, IT Security is promoting the use of Identity Finder to help identify if Social Security numbers are present as stored data on employees' computers. This is so that they can be deleted. Here are some basic technology-related guidelines to help you properly use electronic devices while being careful about managing sensitive data. Don't share passwords or post them by your computer. If you have a laptop especially, have your computer encrypted. In the scenario of losing or having your laptop stolen, having the device encrypted gives the stored information a lot more protection. When emailing, be cautious about what you send. If a message contains sensitive information, consider making that communication in another way instead of an email. Or if you must send an email, encrypt the message. Speaking of emailing, don't rely heavily on auto-populate for the to line. This can lead to misdirected messages of sensitive information. I turned off the auto-populate in my email application. If I'm not exactly sure what my recipient's email address is, I go to the directory and look it up. It's worth that extra few seconds to avoid sending the wrong information to the wrong person. Beware of phishing. Don't open suspicious attachments or click on links that you weren't expecting. I've been getting emails from FedEx saying that I have a package, that the package they sent me needs to be picked up and I should click on a link for something. So delete those right away. If you bring your own device, if you bring a tablet or a personally owned cell phone and do some work on it, the same IT policies as apply to case-owned technology devices also apply to your BYOD device. So therefore, you should be familiar with the acceptable use policy on the IT policies page. And it's a good idea to periodically review the new to crew staff and faculty guides to IT services. Thank you very much for your attention through this presentation. Please feel free to contact me or Boyd Coomer if any questions come up. New scenarios pop up all the time, and we could be a resource to you as you handle private information through your workdays. Thank you very much.